All right, so today we're going to talk about the most common title issues that come about when trying to sell an estate property. I'm Brad for probateresource.com. We're a real estate solutions company. We specialize in the world of probate and inheritance properties. We buy properties for cash, and we also have a fantastic network of real estate agents that we work with all over the country that are probate and inheritance specialists to help you get your property sold. So today let's talk about these title issues. Probably I would say there are four most common title issues. And number one, I'm here with Mike here. Mike is one of the attorneys at a firm here in Georgia that I close a lot of our deals with here in Georgia. And Mike, so obviously you guys run into this a lot. And can you tell us the difference between joint tenants with survivorship or rights to survivorship? We're going to talk about Georgia here, but a lot of states in the U.S. have very similar laws to this. They work pretty much very similar. They might call it something slightly different, but today we're going to talk about joint tenants with rights to survivorship or tenants in common. So sure. Elaborate on that for me, Mike.
Yeah, so those are probably, when you have two people on title, the two most common ways to take title. Now, in the state of Georgia, the default position is tenants in common, and essentially that means, in a simplified way, that both people own 50% of the property if there are two people on title. You could have more, but for this example, two people on title. When one of those people passes away, their 50% doesn't go to the other person who is on title with them. That is their separate interest that would have to be dealt with either through probate or what have you to go to their heirs or so on. With joint tenants with rights to survivorship, both people are on title together. However, if one were to pass away, the other person essentially absorbs the interest that the other person had in the title, and then that remaining joint tenant becomes 100% owner of the property. So to be able to get a joint tenant with rights to survivorship designation on title, you have to specifically list it out on the title that, you know, that John Smith and Jane Smith are taking title as joint tenants with rights to survivorship. Because if you don't, it will be assumed that they are tenants in common. And so we usually recommend, especially for married couples, to do that, because if you do that, if one of the parties passes away, there's not going to be a need to use probate in order to handle any of the interest in the property. And it becomes a much easier, much smoother process as far as going to sell the property. So I think that sort of explains it pretty well.
Yeah, definitely. Yeah, I mean, obviously we always tell people, and if you're not sure about whether you own a property as joint tenants with survivorship or tenants in common, just go back and pull the copy of your deed. You can find it online. You might have a copy in a drawer somewhere, or you can have somebody look it up for you. Usually all these deed records are recorded online nowadays, and it will explicitly say on the deed, if it's with rights to survivorship, it will say it there. If it doesn't say anything along those lines, then the default is tenants in common, right?
Correct.
And in which case, if it is tenants in common, then you're treated as two separate entities, and you will likely need to go through probate in most cases.
Yes.
So, great, awesome. Number two, obviously, I've run into this in many deals. You guys run into this all the time. When you're doing a probate, if you have missing heirs, how do you handle that? What do you do there?
Sure, yeah, and that seems to be real common with letters of administration. And that letters of administration are used when someone dies intestate or without a will, where the court will appoint an administrator to handle their estate and their affairs. So to be able to do that, you have to be able to locate all of the heirs, because all of the heirs have to have a buy-in to that process. And they'll either collectively appoint an administrator, say, hey, we recommend that this person be the administrator, and the court usually will accept that. Sometimes they'll reject it and appoint a neutral third party, but that's not so common. But for the missing heirs, it can be critical because it can really slow down the probate process. I know what we do here, there are various searches that we can do. Obviously not just Google searches, these are more advanced searches to try to locate a person, whether it be through their social security number, previous addresses, workplaces, and then try to find a link to whether it be the deceased person or some of the other heirs to identify the person we found is actually the person we're looking for. Because especially if you have a very common name like John Smith or what have you, there could be millions, and you have to try to find the exact person, and you're not going to want to be calling thousands of people to try to figure out if that's the right person. So we can do that. If it gets really complicated, you can always push it back to the court and allow them to try to resolve it. And sometimes the court, if someone has been missing and a legitimate attempt has been made to find them, sometimes the court will be able to move forward or will allow you to move forward without actually locating that missing person. But at that point, it's really going to be in the probate judge's hands to deal with.
Yeah, and we've had a few cases like that over the years where we're buying a property. I can remember one of them is like one of my first probate deals I ever did. I was dealing with a lady, and her sister unfortunately had fallen into drugs and hanging out with the wrong people many years ago and sort of fell off the face of the earth. And the probate courts had to, I think they had to, in her case, they had to make an attempt to reach out to her at 2 of her last known addresses. They had to actually hire a process server to go attempt to serve her sister at those last 2 places. And then there was a waiting period that they had to wait to allow, give her sister ample time to find. And then once that waiting period was over, then the court proceeded with the probate, issued her letters of administration, then she was able to close it. But it delayed the process a good bit because the courts had to, obviously the courts move at a snail's pace. So if you can do it, from a private perspective, it's a little bit quicker, but there's definitely boxes you have to check and rules you have to follow during that process.
And the court will take its time simply because that missing heir does have an interest in the property, and that interest has to be dealt with. So they want to make sure that they've allowed enough time for that missing person to come forward or to be notified and then come forward to be able to say, I don't want anything to do with this, or I agree with this, or don't agree with that. And so it will be a little bit more time consuming, but it's just kind of one of the things the courts will do just to make sure that that missing heir's interest is appropriately dealt with.
Right, because at the end of the day, the court system in the United States is here to give people due process, right? To give them the benefit of the doubt, to give them a chance to, come forward, right? And the courts are serving the people. So they have to be a little slow just for that very reason right there. Otherwise, people would be pretty pissed if the courts were doing something behind their back, right?
Sure.
Yeah. All right. So the next topic, the most common thing, and you were just talking about this a minute ago, you dealt with this today, is minor heirs.
Correct.
Right. So how do you guys handle minor heirs?
Well, sure. First of all, if someone is a minor, it can create problems because legally they're not able to enter into any type of contract. It's said legally that they don't have the capacity. They can be incredibly intelligent and mature, but just as a bright line rule, until you're 18, you're not able to really contract. So you can't get a credit card, you can't sign a car loan, you can't sign a mortgage. And so if you have a minor heir, it can create problems simply because a guardian has to be appointed usually to deal with their interest in the property. And, referring to the situation I had today, a few years ago, there was an administration of an estate, and they deeded the property to who, I guess he was 14 at the time, and now they're looking to sell. Well, the question becomes, can a 16-year-old sign over his interest on a warranty deed? And the answer is no. So at this point, a guardian's likely going to have to be appointed by the court in order to deal with the minor's interest in the property, and 2, to deal with any proceeds that may be due to him due to the sale of the property. And so it can cause some complications, and that's why we always recommend that you use an attorney to do the probate process, simply because there are these issues that come up, and you're going to create headaches for yourself down the road if you don't handle it properly at the time. And I know that people attempt to do these things because they want to save money, and maybe in certain circumstances in a very simple estate that's possible. But I think in certain situations it's critical that you have a probate attorney or some attorney that deals with these types of situations to handle it for you.
Absolutely, and I've done some other videos about this before. If you're worried about the financial aspect of hiring a probate attorney, I mean, Mike can attest to this. I work with a lot of probate attorney firms, and a lot of times all we do is the probate attorney will agree, usually they'll take a small retainer up front, and then they'll just bill the rest of the proceeds for their cost of their probate out when the property is sold. So we'll just have the probate attorney send their invoice over to you guys, and then you guys just pay it out on the closing statement, and the attorney gets paid, and everything's good.
Yep.
And then you don't have to worry about fronting that. You know, hiring a probate attorney can be obviously thousands of dollars, and the more complicated an estate you get, the more expensive it can get. So if you're worried about that cost, there are ways to sort of alleviate that cost a little bit and basically pay those out when the property is sold so that you don't have to worry about paying that out up front. So thanks for that answer, Mike. So the last thing we're going to talk about is this is something is here in Georgia, but it does apply in other states. And also, if you're in a state other than Georgia, a lot of stuff we're talking about here is pertaining to Georgia law because Mike is a licensed attorney in Georgia. But if you're in another state, I would highly advise you to consult with an attorney in your own state that knows your state laws. And if you need a reference to an attorney, we have a small network of attorneys that we work with, that we refer our cases to, that we get in at probateresource.com. Be happy to refer you to one of those attorneys. But let's talk about here in Georgia, which is, I call it a way around probate per se, which is called an affidavit of descent. So let's talk about affidavit of descent.
Sure.
What does that mean? What is that all about?
What the affidavit of descent does, first of all, it doesn't apply to all estate situations. First of all, a person has to have been deceased for more than 3 years. It doesn't have to be many days over 3 years. In fact, it could be the next day after 3 years. And basically what you're doing in an affidavit of descent is the person who is filling out the affidavit and signing the affidavit is saying a few things. One, I knew the deceased person. Two, I've known them or knew them for so many years. And usually for an affidavit of descent, you're going to want to find somebody who's known the person for a while. Usually our title insurance underwriters, depending on the situation, 10 years, maybe sometimes as many as 20 years. So you want someone close who can really speak to the nature of that person's family situation, who their particular heirs were. And so that person is saying, I knew the person, I knew him for this long, they lived at this address, they had this many number of children, they had this wife, maybe they were married previously, had kids from that marriage. They can basically lay out the life story of a person in a single document. And then with that, it's enough for most title insurers to say, okay, probate wasn't done, but we know these are the heirs, these are the people that we need, whose interests we need to deal with. And then, so with the affidavit of descent, there's usually a two-step process. You get the affidavit, and then you get the heirs to do, and I know we may talk about quitclaim deeds, to quitclaim deed their interest away on the property, or to sign off on a single warranty deed together, basically saying that we're releasing any interest that we may have in a particular property. In Georgia, it's usually called the affidavit of descent. In many states, they call it an affidavit of heirship. Basically the same document. The formatting is slightly different, but it's essentially accomplishing the same thing.
Yeah, definitely. And like you mentioned, like I've mentioned this in other videos, across the country, I would say probably most probate law from state to state is about 80% the same, right? And there's like 20% that varies from state to state. So one state might call a document something else, but in essence, they do a similar thing. Actually, I was going to do 4 topics here, but you just reminded me of another topic. So
Sure.
Quitclaim deeds. Wow, I can't tell you how many times I've dealt with quitclaim deeds. So let's talk about quitclaim deeds here.
Sure. So a quitclaim deed is a valid deed where a person passes interest to another individual or entity, their interest in the property over. There are some problems with quitclaim deeds, or some things that can cause problems. First of all, when you do a quitclaim deed, you're not guaranteeing the quality of title or warranting whether or not title is clean or that you even have valid title. I mean, you can receive a quitclaim deed from someone with no title search and not even really knowing whether or not that person's the valid owner of the property. So that's a problem. Another issue with quitclaim deeds is a lot of commercial lending institutions, major banks, they don't like to see those. They would prefer a warranty deed or a limited warranty deed. And then finally with the quitclaim deeds, they're often done by individuals outside of law firms. So they'll download a template off of a Google or what have you. They'll either hand fill it in or they'll type it in. And more often than not, they don't do it correctly. Because even though you can find a template online, it doesn't necessarily mean the template is drafted to the standards set forth by the state of Georgia. Because the deeds have to be drafted a certain way, contain certain language, signed a certain way, witnessed a certain way, notarized a certain way. And more often than not, we see in our title reviews that people use quitclaim deeds incorrectly, and they're incorrectly drafted and or executed. And then what happens when you're going to sell the property, the closing attorney will have to then try to go back and fix the mistakes that were made in the quitclaim deed conveyance, which can be easy, but it can be more challenging at times also. So in certain situations, husband and wife get divorced. They bought the property together. They had title together and title insurance together when they purchased. Now husband is deeding to wife his interest. Quitclaim deed would probably be completely appropriate in that situation. Once again, usually recommend you do it through an attorney, but that's an appropriate situation. But in terms of just buying a house from someone or passing it on to someone, we usually recommend a full title search, doing some sort of warranty deed, and making sure that whatever it is you're purchasing or conveying has clean title to the property, and that you know and can trust that what you're getting is actually yours once it's deeded over to you.
Absolutely. And there are circumstances where people have come to us to want to sell a property, and I've looked at and I see, well, they acquired this through a quitclaim deed, and then it's kind of hand it off to you guys, and you start doing the title search, and you find out that Johnny Smith, who's trying to, sell me this property, is not actually the rightful owner of this property, right? And y'all's job, obviously, you're a representative of the title insurance company. Your job is to do your due diligence and make sure that that chain of title is clean and there are no breaks in that chain of title and everything is good, because you're warrantying to the title insurance company that says, hey, we've looked at this, everything looks good to us. We're willing to insure this title against any potential defects. And I know for a fact, I had a title claim a few years ago, and it ended up in litigation for two and a half years in litigation, and it would have cost me a lot of money, and we did everything right. Mm-hmm. So, it's very critical, if at all possible, if you're transferring title from an estate or anything, just reach out to an attorney. Even if you're doing a quitclaim deed, an attorney like you guys will probably only charge a few $100s to do a quitclaim deed. It's not that much money to do it.
And not even to do the quitclaim deed. If you just wanted a basic title search done prior to the quitclaim deed, that's usually relatively inexpensive too. Now, obviously, if you want to get insurance and everything, it adds on. But if you just say, hey, I want you to draft me a quitclaim deed, and while you're at it, before you do that, I want to pay you to research the title and to clear the title, we can do that also. And then that way, whatever you're doing, it gives you a certain peace of mind that, okay, I know what I'm doing is correct. I know what I'm conveying is what I can actually convey. And it just gives everybody in the transaction, makes them feel better about what they're doing.
Yep.
So
absolutely. Yeah, there have been some instances. I remember Josh, your attorney that you work for, we had a situation with an estate and a family, and the mom had deeded it to a daughter or whatever, and the quitclaim deed wasn't done right. and mom had to fly into town, and Josh had to go meet her down at the airport and get her to sign another quitclaim deed because they didn't execute the original quitclaim deed the proper way. And we ended up having to pay for her to fly into town. Josh had to go meet her down at the airport, sign everything. It all ended up okay, but you know, do it right the first time, right? All right, guys, well, those are the most common title issues that they encounter at their firm here. So if you've got a property that you need to sell, you've inherited, we'd be happy to make you an offer on that property. Probate and inheritance is what we do. We make cash offers on properties, or if you want to go the traditional route, maximize every last dollar you want to get out of it. I actually have a hand-picked network of real estate agents I work with all across the country that are experts in the probate inheritance world. Be happy to connect you with one of those agents. So if you want to work with our company, please go to our website at probateresource.com. There's a form there on the website you can fill out, or you can pick up the phone number there on the site and just give us a call, and we'd be happy to talk to you, discuss your situation, figure out where we're the right fit. So thanks again for checking out this video. Thanks again, Mike, for your time. Have a great day. Bye-bye.